It's only fair, fair housing law and practices. Imagine you call on an apartment, make arrangements for a viewing, drive 10 minutes across town, and step out of the car. The landlord takes one look at you and says, "So sorry, the apartment is taken." You wonder, has the apartment really been taken in so short a time? Or is this discrimination based on the color of your skin, or the child who hopped out of the car with you, or the wheelchair you pulled yourself into? What do you do? Illegal discrimination in housing is real. It happens in Vermont, and it often goes unreported. Here's what you need to know to get help when you need it. Let's begin with a quick look at the law. The U.S. has a long history of discrimination in housing. Since the 1960s, laws have been passed to ensure that everyone has an equal opportunity to choose where they live and equal right to enjoy their home free of discrimination. This matters as where you live determines where your kids go to school and your access to jobs, healthcare, grocery stores, and more. Based on our history of discrimination, the law established protected classes, meaning that members in a protected class are given specific legal protections against discrimination. So, what are the legally protected classes? There are two categories, federal and state. First, the federal. No matter where you live or look for housing in the U.S., you have legal protections based on whether you have a disability, your race, sex, or color, where you are from, or national origin, what religion you practice, or whether you have children younger than 18. Vermont has additional protections. In Vermont, you are legally protected from discrimination based on whether you receive public assistance, like 3 Squares Vermont or a Section 8 voucher, your gender identity or sexual orientation, whether you are married or not, or your age. And most recently, victims of domestic violence, sexual assault, or stalking have additional protections: the right to have the locks changed, the right to break a lease with notice, and the right of confidentiality. Keep in mind these federal and state protections apply in many housing situations, not just when you rent. They also apply when you seek to buy a home and when you seek financing, such as a mortgage, in all housing-related transactions, and when you are living in your home. Harassment of all types, including sexual harassment, is also covered under the law. Based on membership in a protected class, it is illegal for a landlord to refuse to rent to you, make housing unavailable, set different terms, conditions, or privileges for a rental, to steer you to a different neighborhood or type of unit, refuse to make reasonable accommodations if necessary for a disabled person to use the housing. It's perfectly legal to refuse to rent to someone because of poor references or bad credit. And there can be different rules or practices because of behavior, but not for membership in any protected classes. For example, a landlord can't say that children are not allowed to run in the hallways, but they can say that no one is allowed to run in the hallways. Illegal discrimination can sound like, too many kids, I don't want a ramp here, no Section 8, only English speaking. In Vermont, the majority of housing discrimination complaints are based on disability, followed by race and color, and families with children. Disability protections cover not only physical disabilities, but also cognitive and emotional disabilities. For example, someone with an emotional support animal has a right to request an accommodation from a no-pet policy. People in recovery from addiction also qualify for protection. While landlords do have a right to deny housing based on someone's criminal background, if the criminal record is due to activities to support an addiction, such as passing bad checks, and the person is in recovery, then the person could request an accommodation from that rule. Sometimes families with children hear there is an occupancy limit for an apartment. Is this a way for landlords to say no if the family has children? Maybe, but maybe not. An occupancy limit could be due to fire safety regulations, to be sure the people living in a given space can easily get out in case of fire, or due to local wastewater regulations. Anytime you're unsure, call us. In general, though, most occupancy standards limiting tenants to 2 people per bedroom do not violate fair housing laws. However, rules that limit the number of children per housing unit instead of the total number of people per housing unit are discriminatory. Section 8 vouchers are a form of public assistance, and it is illegal in Vermont to advertise apartments as not Section 8 approved or will not accept Section 8. Landlords must allow rent payments from housing assistance programs and must allow a Section 8 inspection. Please report or reach out to ask questions. There are 3 places you can call if you feel you have been discriminated against in your housing or housing search. CVOEO's Fair Housing Project is a good first step. We can help you figure out if your situation falls into the illegal discrimination category, assess next steps, and help you fill out complaint forms. Our number is 802-660-3456, extension 106. If you are ready to file a complaint, you can reach out to Vermont Legal Aid at 1-800-889-2047 or the Vermont Human Rights Commission at 1-800-416-2010. You can also file complaint forms found on their websites. Fair housing law can be complicated, and we've only touched on a few basic protections and resources. And keep in mind, all tenants have rights and responsibilities under Vermont's rental housing laws. Our tenant hotline is a great place to go if you have questions about renting in Vermont. Simply call 802-864-0099. Through our hotline, we provide information and referrals on leases, security deposits, repairs, evictions, fair housing, and more. Vermont Tenants also provides classes, workshops, and advocacy for tenants. Thanks for watching.